Former Indonesian Education Minister Nadiem Makarim is under intense scrutiny over a controversial Chromebook procurement program, a case that could cost the state nearly 2 trillion rupiah. But what exactly is he accused of? Why did his pre-trial motion fail? And what legal strategies could his defense use? Today, we'll break it all down. Right? In this video, we'll cover 3 main points. The allegations that led to Nadiem being named a suspect, his pre-trial motion, and why it was rejected, and what I would argue if I was his lawyer. The Attorney General's Office, or AGO, named Nadiem Makarim as a suspect in the Chromebook procurement case covering 2019 and 2022. The allegation is that Nadiem planned the use of Google products, specifically Chrome OS, long before the procurement officially began, instructing that only Chromebooks be used. Now, according to the AGO, this allegedly limited competition and caused a significant financial loss to the state, around 2 trillion rupiah. Now, legally, he's charged under Article 2, Paragraph 1 and Article 3 of Law Number 31 of 1989, amended by Law Number 20 of 2001, also known as the Corruption Eradication Law. Article 2, Paragraph 1 makes it a criminal offense for anyone who intentionally causes a loss to the state or economy through unlawful acts. Now, this is often applied to cases where mismanagement or favoritism leads to substantial state losses. And Article 3 covers cases where the corruption involves benefit to oneself or another party, even if there's no direct financial loss, emphasizing the legality of self-enrichment through official duties. And Article 51, Paragraph 1 of the Indonesian Criminal Code, or QHP, this article addresses collaboration in criminal acts, making anyone who conspires, assists, or participates in a crime liable alongside the main perpetrator. And in Nadiem's case, the AGO alleges that his instructions and involvement in the procurement process could implicate him in a form of collusion with subordinates or external parties benefiting from the contract. And these laws form the backbone of the prosecution's case, emphasizing both the intentional element of the wrongdoing and potential collusion in causing state losses. Following his suspect status, Nadiem filed a pre-trial motion at the South Jakarta District Court, claiming the AGO lacked sufficient initial evidence to justify his suspect status. The calculation of state losses was not supported by official audits. However, on October 13, 2025, the court rejected his motion. The judge ruled that the AGO already had 4 valid pieces of evidence under Article 184 of the Criminal Procedural Code, making the suspect status legally valid. The decision allows the investigation to continue, moving Nadiem closer to a trial. If I were Nadiem Makarim's lawyer, here's how I would structure his defense. I would argue that Nadiem never had any intention to enrich himself or anyone else. Under Article 2 of the Corruption Law, proving criminal intent is essential. If I can show that all of his decisions were meant to serve the education program, this element of the offense is missing. I would emphasize that his actions were part of his ministerial duties and legitimate policy making. According to the Criminal Code, Article 50, officials acting within the scope of his authority are protected. So these decisions fall under lawful administrative discretion. I would challenge the methodology used to calculate the alleged 2 trillion rupiah loss, questioning whether the state truly suffered a financial detriment. I would rely on BPK guidelines to argue that the figure may be inflated or miscalculated. I would highlight Nadiem's full cooperation during the investigation, providing documents, data, and testimony under the Criminal Procedural Code, Article 50 and 21, the Corruption Law, on Article 65, showing transparency can serve as a mitigating factor in potential sentencing. Finally, I would stress that the Chromebook program was designed to expand digital learning in schools. Even if there were financial inefficiencies, the overarching purpose was public benefit, not personal gain. This frames the actions as legitimate public policy rather than corruption. Nadiem Makarim's case highlights the complex intersection of public policy, corruption law, and ministerial responsibility. So what do you think? Is he a victim of politics, or is he actually guilty? Comment below and share this video with your friends. Thank you, bye-bye. Hi, my name is Peter. I've been asked so many times, Peter, how do I learn to speak English as fluent as a native speaker? You know, I'm tired of answering people one by one, so I wrote a PDF about it. Based on my experience, my method is very simple and practical, unlike school and academic methods. It's perfect for anyone who wants to speak English very fluently and achieve a high TOEFL or IELTS score. If you're interested, I'll send it to you for free. I also created a video version of the PDF for those who don't like reading, plus a video on how to practice by yourself, right? You'll get everything for free. Thank you, bye-bye. Hey, by the way, before you go, don't forget to follow my Instagram at Peter Powers. I have over 1,000 videos on my page that you might find insightful, okay? Bye-bye.